A warrant is a court order telling law enforcement to arrest you. The two kinds you are most likely to already have are a bench warrant, issued when you missed a court date or violated a court order, and an arrest warrant, issued when there is probable cause you committed a separate offense. Either one can surface the moment an officer runs your name during a DUI stop. For many first-time DUI arrests, an officer has the option to release you with a notice to appear rather than booking you. When an outstanding warrant exists, that discretion often disappears. The warrant itself requires you to appear before a judge, so you are more likely to be taken in and booked. Bail becomes more complicated too, because the court handling the warrant may set its own bail amount completely separate from any bail on the DUI charge. If the warrant comes from a case in one county, and your DUI arrest happened in a different county, you are now dealing with two courts at the same time. Each has its own prosecutors, its own clerks, and its own hearing dates. Missing a date in either one creates yet another problem. Coordinating both proceedings so a step in one court does not accidentally damage your position in the other is one of the more practical reasons to have a single attorney who can appear in both places. California law gives you 10 days from the date of your DUI arrest to request a DMV administrative hearing, or your driving privilege is automatically suspended. An outstanding warrant does not pause that clock, extend it, or change it in any way. People sometimes get so focused on the warrant situation that this deadline slips by. Missing it is a separate and serious mistake, completely independent of whatever is happening with the warrant. Judges pay attention when a defendant arrives with an open warrant. It signals to the court that legal obligations have not been managed, and a prosecutor may use that to argue against lenient terms. If the underlying warrant was for a prior DUI that was never resolved, it could count as a prior offense or an aggravating factor in your current case. A DUI arrest while already on probation for any offense is also treated as a probation violation, which can trigger a separate hearing and possible jail time on top of the new charges. Not every warrant needs to be cleared before your DUI case moves forward, but the sequence matters. In some situations, resolving the warrant first removes a significant lever the prosecutor was holding. In others, a global resolution, settling both matters in a single negotiation, produces a better outcome. Courts also respond to defendants who take concrete action, enrolling in an alcohol program, completing community service, or addressing the issue that created the warrant. These steps are documented and presented to the judge as evidence of good faith. If you are dealing with both a DUI and an outstanding warrant, the pieces of your case interact with each other in ways that are worth understanding before your first court date. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.